Hello and welcome again. Before proceeding with today's talk, I'm bound by common decency to once again acknowledge the outstanding work and support of my producer, Tony Lambert, of Secret Harbour Sessions. Tony has been producing very high quality work for some decades now. He has developed his skills both as a writer and an expert exponent of the technological processes involved in producing not only videos and public presentations featuring world-renowned presenters such as Janet Ossebard, but works of literature which are very enjoyable. His novel Pilbara Shadow Play and his 10 short stories, Tales of Horror, Humour and the Occasional Splat, are delightful reads. Tony is also a gifted musician who has played in numerous bands, produced CDs of thematic soundtracks, and he has also produced a book which features contributions from many of the children at the local school while he was living in Cervantes. I've said before that I'm in awe of his accomplishments and feel humbled that he sees fit to devote his time, resources and talents to assisting my efforts over the past 3 years. If anyone watching has any desire to improve the quality of their output on social or other media, I can only give the highest recommendation, not only of Tony's expertise, but also of his personal integrity. Previous videos in this series have been designed to be informative, covering topics which are unfamiliar to very many people. Last time I closed by saying that we would be looking at some of the modern convolutions of thought concerning the rightful roles of jurors in the performances of their duty. Again, delving into this involves the analysis and consideration of principles of both the law and the individual. A recent case in England of a woman who was charged with contempt of court for displaying a sign outside a court which hinted at the juror's right of annulment, a fact which the legal profession is most anxious to conceal from jurors, has provoked much discussion. And we'll be returning to that, and in particular, the wording of the sections of the judgment in future talks. But before that, there are other, more broad questions to consider. I'll be presenting some of these questions for each viewer to ponder, since they involve matters of conscience, and I would welcome any comments from viewers from whatever perspectives each may wish to approach the scenarios presented. The object of this is to provoke serious thinking about some of the most important issues the average person may have to confront in their life, especially if they're ever called up for jury service. Let's begin with a scene where a family are the victims of a home invasion by armed criminals, demanding money with menaces. In this situation, there are 3 main alternatives confronting the family. That is the reason for the title of this talk. The Greek philosophers usually maintained that there are always 3 alternatives. Option 1. Whoever heads the household states that they refuse to kowtow to lawlessness and that whatever the invaders demand, they will not be complying, no matter what. Option 2. The household head reasons that safeguarding the welfare of their family should temporarily take precedence over their personal principles and agrees to comply under duress to minimize harm to the family. Option 3. The head may choose to engage the invaders in some form of dialogue, hoping to stall the crucial moment in case something turns up, for example, an unexpected interruption, or a chance to escape or turn the tables. Let's now consider the situation where one is called up for jury service. We already know that the court system as it exists is corrupt, and we wish to have as little to do with it as possible. Nevertheless, a court summons involves threats of punishment for non-compliance, so we have a choice of trying to get ourselves excused from jury duty on one of the several grounds that permit this. If that's our choice and we succeed, that's basically the end of the matter. If our application for excuse is refused, we still have option 1, where we refuse to comply, simply stating that we consider the court to be unlawful and accept with resignation whatever penalties are applied. But what of option 2? How could this apply to a summons for jury duty? Option 1 could involve large fines or possibly even imprisonment for contempt of court, and this might well affect our family or loved one's welfare for a while, or to a considerable extent. So we could go for option 2, compliance under duress to minimise harm, which is lawful. What would happen if we chose this option and turned up for the jury selection process? Those running the court don't want people who know about and support the principle of jury annulment sitting on juries, and are on record as having told direct lies to conceal this right. So there are often questions asked of potential jurors designed to weed out anyone who might disturb the trial process from the legalist's point of view by having influence in the deliberations room. These questions won't be direct regarding jury annulment, as they don't want to display existence of the concept to the majority of those present, most of whom won't know about it anyway. It would simply open a can of worms, needlessly prompting questions in the minds of the uninitiated. The questions will therefore be indirect, designed to trick or manipulate those in favour of jury nullification into revealing their status as a potential troublemaker. An example might be, quote, "Do you understand that you will be instructed to judge the case purely on matters of the law, and to take an oath to do so, and to abide by that oath," end quote. At that point, one could reveal that one supports the principle of jury nullification, and this means that one reserves the right to acquit if, according to one's conscience, the law or legislation is unconscionable, unconstitutional, immoral, or unjust. And that would see one removed from the jury selection process before such a sentence was even fully uttered. But when we examine the question, it doesn't ask directly if one supports jury nullification, nor does answering in the affirmative mean that one is committing perjury or lying to the court. A yes answer means that we understand we'll be instructed to adhere to the law, to swear to do so, and to abide by that oath. By being deceptive and manipulative, the court is hoisted by its own petard, as the saying goes. For we understand that the process of jury annulment is not only a right under natural law, but is actually a duty of a juror, because by so doing they prevent harm to an innocent individual. The right to annul unjust legislation has been well established by the Bushell case in 1670. In that case, the jury was imprisoned for not following the judge's directives and returning what the legalists call a perverse verdict. But this was overturned on appeal, and the precedent stands to this day. In another recent case, a man charged under so-called hate speech laws was acquitted after only 17 minutes of jury deliberation. The jury obviously regarded the legislation as morally repugnant, as it abused the right of individuals to free speech, and was given what can only be described as very short shrift. Thus, jury annulment in the situation described above would be fully in honour of that juror's oath, because they had abided by each aspect of the question asked. Is it the fault of the juror that the court officers decided to conceal the lawful rights of the jury, in the hope that no one would be aware of those rights? This deceptiveness is at the heart of the legal profession's reliance upon the individual's ignorance of their rights, thus naively consenting to an illegitimate process. Seeking an affirmation from someone to engage in certain actions without revealing all of the relevant facts and conditions of the contract is fraudulent. But the legislation is set up to permit such miscarriages of justice if the individual is insufficiently motivated to learn the facts. Option 3 in the home invasion example isn't really applicable here. It's possible that the case might be abandoned over some technicality or other, but if summoned to appear for jury service, I wouldn't be betting on that outcome as a possible escape route. The real question here is whether one deliberately excuses oneself from jury service or decides to enter the process with the aim of possibly bringing about an annulment if the case involves repugnant legislation. There are those who argue quite correctly that the current judicial system is hopelessly corrupt, and that persons of conscience would have nothing to do with it, as to do so is simply to step onto the devil's ground and hope, frequently in vain, that one can bring about some good or at least minimise harm from within the system, and without affecting any long-term change. On the other hand, there are those who argue that they see a pernicious system of harassment inflicting harm on an innocent person, that is, one who has done no harm. Furthermore, this system is bent on continuing that process of harming the victim, with the ultimate aim being to enrich some of the practitioners of the system by either fees or fines, with the moral aspects having either a very minor consideration or no consideration at all in the matter. These people perceive that the process of victimization is going to continue whether they participate or not, and reason that it's better for their consciences that they try to prevent the wrongdoing by whatever means are available. In this sense, it's analogous to someone interrupting or turning the tables on a criminal gang of home invaders. In each case, a criminal entity is intent on inflicting harm, backing their actions with coercion or force. Bystanders may either excuse themselves and walk on, or if pressed to participate, may either decline or decide that what's happening is wrong and become involved with the hope of somehow turning the tables on the aggressors, maybe even using the aggressor's own weapons. In the court case, that weapon would be the annulment of unlawful legislation in that particular matter. In either scenario, criminals and their activities are going to continue until such time as sufficient numbers of individuals assume their moral responsibilities and act meaningfully to bring about a greater degree of adherence to natural law in the community. That is our task, to bring about enough change of hearts and minds in the aggregate. The point is that in either of the examples discussed, the ones disqualifying themselves from the corrupt trial, or the ones seeking to prevent unlawful harm to their fellows by seeking to get on the jury and somehow effect an annulment, can both be said to be acting from their consciences with good intent. It's an illustration that in matters of justice, there are very often nuances of principles and thought to be negotiated, not just between individuals, but also within each one. It's possible for decent people to use their consciences honestly, yet still choose differing courses of action. This is the essence of the trial by jury system, and why it's better to have 12 people of similar backgrounds to the accused, rather than a solitary figure who may well have little in common with that one, deliberating upon such serious issues. Ultimately, we each have to place a substantial degree of trust in each other to behave honestly and lawfully before we can hope to have a peaceful, harmonious community. When breaches of that trust occur and crime happens, it's necessary to place that trust upon those selected for jury service. David Hume lauded the trial by jury system as the one best of any yet devised by the wit of man to minimise the occurrence of injustice. Yet as humans we are all flawed, so occasionally the outcomes are less than perfect. But that doesn't excuse us from striving for the best that we can achieve. Over time, social mores and customs change, and the trial by jury system is the best to reflect this in how laws are applied. Crimes will always be crimes, consisting of individuals' rights being infringed by others. But often things which are termed crimes are really only vices, or in many cases hardly even that. What a jury today, for instance, would dream of punishing someone who escaped from a slave owner, or had a consensual relationship with a same-sex partner, as they usually would have 150 or even 80 years ago. Trust is the basis of a worthwhile community, where all are accorded equal status before the law. Maybe that's why Ricky Gervais recently said, "Of course you can't trust those in charge. That's why they're in charge, because they can't be trusted." Thank you for watching.